Yeah, Assembly Member Gibson. Welcome to the committee, AB 835.
Thank you very much, Madam Chair and members. AB 835 will ensure those committing vehicle homicide and flee the scene are held accountable for their crimes. By tolling or suspending the statute of limitations, so it is not to begin until a suspect is identified, AB 835 will give law enforcement 1 year period to file charges against those committing this crime who have fled the scene of a crime. In Los Angeles County alone, there is an average of 6,000 hit-and-run accidents that result in death and injuries every year. AB 835 will give law enforcement the tools to prosecute these cases and provide justice for the families whose lives have been shattered as a result. With me today are representatives from the Crime Victims United and the Los Angeles District Attorney's Office who provide testimonies.
Thank you. Perhaps we could, yes. Witnesses in support.
Madam Chair, members, Dan Filizzato on behalf of the Los Angeles District Attorney's Office and the Crime Victims Action Alliance. This bill addresses a real problem with existing law. While the cases involving a hit and run and death are rare, the existing law provides what we deem to be a perverse incentive for the individual to flee, because if they don't stop and they flee the scene, if they're not identified within the existing statute of limitations, there's nothing law enforcement can do to address these horrible situations. Our office in the last 3 years has come across 2 cases where we had homicides, hit and run accidents, where murder wasn't an appropriate charge. So manslaughter was the appropriate charge, but the statute of limitations had expired, and so there was nothing that could be done. This bill will allow law enforcement in those rare cases where there's a death and a person flees and the statute of limitation is run, but then the perpetrator is identified. It gives us 1 year to bring charges against that individual. This is very similar to what the legislature has done with victims of sex crimes. Because of the existing incentive in the law not to stop at the scene of one of these horrible accidents, we ask for your aye vote.
Thank you, Madam Chair. Dawn Kepke again on behalf of Crime Victims United of California, also in very strong support. We really feel very strongly that accountability is important when we're considering this bill, and to the extent that an offender is identified for this really very tragic set of circumstances and crimes, that they should be held accountable. That said, protections being the 1 year time frame once they've been identified, we think is reasonable, and really feel that this is an important accountability measure for those victims' families. So for this reason, we very strongly support the bill and urge an aye vote.
Thank you.
Ryan Sherman on behalf of Los Angeles County Professional Peace Officers, Sacramento Deputy Sheriffs, Long Beach, and the California Fraternal Order of Police. We're in very strong support of this bill as well for the reasons stated. Thank you.
Thank you.
John Lovell on behalf of the California Police Chiefs Association, Los Angeles County Deputy Probation Officers, Association for Los Angeles Deputy Sheriffs, Association of Deputy District Attorneys, Los Angeles Police Protective League, Riverside Sheriff's Association, California Association of Code Enforcement Officers, California College and University Police Chiefs Association, and the California Narcotic Officers Association, all in support.
Sean Hoffman with the California District Attorneys Association, also in support.
Thank you. Others in support? Speakers in opposition to the bill? Please come forward. Please make room for them at the table.
Micah Doctoroff on behalf of the ACLU of California, here in respectful opposition to the bill. Statutes of limitations promote one of the core principles of our justice system, that being that crimes are solved and brought quickly to trial to ensure that a person accused of a crime faces reliable evidence and has a fair opportunity to mount a defense. AB 835 would effectively eliminate the statute of limitations for charges brought under Penal Code Section 192C1 or 2 in cases where a person flees the scene of an accident. The bill would permit the prosecution to pursue charges within 1 year of identifying a suspect without any outer limit on when charges may be filed, which would essentially have the same effect as there being no statute of limitations, as the prosecution would be able to pursue charges decades after the events at issue. Penal Code 803J, in contrast, currently provides that in cases where a person flees the scene of an accident causing death, the prosecution may file charges within 1 year of identifying a suspect, but in no circumstances later than 6 years after the commission of the offense. Amending the statute of limitations in AB 835 to align with 803 would alleviate confusion between the two code sections, would promote justice, and would ensure that people facing criminal charges for this offense be afforded a fair opportunity to mount a defense. For these reasons, we respectfully oppose unless amended.
Members of the committee, Jesse Stout, Legal Services for Prisoners with Children, LSPC, also in respectful opposition to AB 835. Our group, LSPC, advocates for reducing incarceration and its harms, so we would oppose this law that would put more people in our state's prisons and jails. In particular, this bill attacks statute of limitations, which we believe would not be an efficient option for addressing crime in our state. Statute of limitations exist, in part, to ensure that evidence has not been excessively corrupted or degraded. This bill could conceivably result in prosecutions for crimes alleged to have occurred an unlimited number of years ago, long after physical evidence such as DNA has disappeared, memories have faded and become less accurate, and potential witnesses have dispersed. Many life events, beginning careers, starting families, even physical aging, can further fade memories. We believe that increasing the statute of limitations to cover such a wide span of years, again potentially unlimited, will create more problems than it solves. In the case of this bill, because the police would be able to identify a suspect at any time, regardless, of course, of whether that suspect is, in fact, the person who committed a hit-and-run accident in this case, there would be no limitation on when a suspect could be identified or when a crime could be prosecuted, allowing the possibility that a crime could be prosecuted even after all witnesses to an accident have deceased or left the area. In particular, we heard testimony from the support witnesses that the Los Angeles District Attorney's Office has identified only 2 cases in the last 3 years, showing that this bill would affect a small minority of cases and be ultimately inefficient in addressing the problem it seeks to solve. For all of these reasons, we ask for your no vote on this bill as drafted. Thank you very much.
Okay. Are there questions or comments from members of the committee? Senator Anderson?
Assemblymember, can you speak to the ACLU's objections cited with the code?
Sure. Did you want to weigh in on that?
As the bill, I believe it was last year, the Gatto bill that the ACLU referenced, it did extend the statute of limitations for 6 years. However, when you look at Vehicle Code Section 20,000.1, I believe it's subdivision D, that section provides for an enhancement in cases where a death and manslaughter charge are brought. But if you read that section, it can only be brought, that enhancement can only be brought if there is a manslaughter conviction. If the statute of limitations are not extended the way AB 835 proposes, that enhancement is useless because it requires that the manslaughter charge be brought and that there's a conviction under that section. If the statute of limitations is run, I cannot bring that charge. There can be no conviction.
I see. Assemblymember, I don't know if you want to add to that. I want to
Sure.
cut you off.
Sure, I absolutely want to add to it. I would beg to differ that there is a statute of limitation. When someone kills someone in a crosswalk or on the streets, we hit the pause button, until the individual is identified. And then once an individual is identified, then the pause button is released and you have a 1 year to bring charges and prosecute that individual. Let me also say this, Senators. This gentleman right here to my right indicated in terms of memory loss of a suspect. What you don't know is that my son was killed at 3 years old. Just 2 weeks ago, Crime Stoppers reenacted the crime that took place that was filmed 2 years ago. Our son was killed while my wife was with AAA across the street getting her tire fixed. Deontay was in the custody of a family friend. Just as many children do when they see their parents, they get excited, mommy, mommy. He broke out the door, ran between two cars, was hit by a hit-and-run motorist, a woman. The last words my wife heard was, mommy, mommy. The lady got out of the car, came to where Deontay was lying in the streets, ran and got back in the car. The tow truck driver tried to apprehend and get some information. I beg to differ. My wife has a visual memory of the woman every single day, what she looks like. And this woman is still outstanding. If the woman would come in here in this room today and sit right next to me, there's not anything that anyone can do to prosecute that woman for taking our child away from us. Every birthday, every Christmas, we go to a cemetery. This bill will not bring our child back, but it will give the families who will be faced with this situation some kind of hope that law enforcement is out there trying to bring to justice an individual that has taken their child, their loved one away. And I'm simply saying, because the law, we have no statute of limitations on murder. When someone evades police, and I'm a former police officer, hits someone and takes off to evade being captured, and that person is still at large, what is that person doing? They can wait out the statute of limitations. This bill will only put a pause and say until we identify who this individual has committed this heinous crime, will be brought to justice, then the pause button will be released, and then we can move forward with prosecution. We must give some kind of rest, some kind of peace for families. This will not bring my son back. It would not bring him back. But to give some families some comfort and knowing that law enforcement is not going to give up until they find this person who have taken their loved one away, I think it's the right thing to do.
Assemblymember, I'm so sorry for your loss, and if you take an amendment, I'd like to be added as a co-author, and I'd like to move the bill.
Thank you.
What's the amendment?
I said if he takes an amendment later to add me as a co-author.
Oh, okay. I didn't, yeah. I was just interested in, somebody said there were only 2 cases that came up, which in the last couple of years, if you could just elaborate a little on that, Mr. Lozado. To me, that says this is something that is not a major change in law, but something that would allow in the situations where we do find the perpetrator.
And as I stated in my testimony, these situations are rare. But unfortunately, the law does provide an incentive for somebody to flee the scenes of a hit and run where there's a death, because if they can evade the statute of limitations. The case I'm most familiar with in Los Angeles County involved an individual who ran a young woman off the road and basically forced her into a telephone pole. She died on impact. They were the only 2 cars in the area. There were no witnesses. The perpetrator, though, had a passenger in his vehicle with him. I believe it was 12 years after the statute, or 12 years after the accident, 5 years after the statute had expired. The passenger in the vehicle had a crisis of conscience and came forward and reported what had happened to law enforcement. There was some physical evidence that we were able to tie to the vehicle because the owner still had the vehicle. But because that statute had run, my deputy had the horrible duty to inform the parents that we now knew who had killed their daughter, and that there was nothing that we could do about it. Because in this particular case, murder was not an appropriate charge. The other case, I'm sorry, I don't really have a lot of the facts.
Okay,
involved.
I was just trying to understand a
But
little
it
bit
is-
more
this is
about
a
how this
rare-
would play out in the real world.
Yeah, it is a
Yeah.
rare situation.
Yeah. Well, I also can appreciate the great loss that you suffered.
Thank you.
And I spent a great deal of Friday night with the families of the Irish young people that fell from the balcony in Berkeley. And when those things happen for a parent, it's unbelievable. So this might be a way of moving forward from there.
Thank you.
And I would support the bill today. It's been moved by Senator Anderson. Please read the roll. Oh, would you like to close?
Just respectfully
Sorry.
ask what I vote. Thank you.
Thank you.
Hancock.
Aye.
Hancock, I. Anderson.
Aye.
Anderson, I. Glazer. Glazer, I. Leno. Leno, I. Liu. Liu, I. Monning. Stone.
Okay, it's enough votes. We'll hold the roll open for the
Thank you very
absent
much.
members. Assemblyman Levine. Oh.
Thank you, Madam Chair and members. AB 899 protects children from improper disclosures of their confidential information. Existing law prohibits disclosure and dissemination of juvenile information without explicit authorization from the court. This bill simply reiterates that federal officials, including immigration officials, are not exempt from having to petition the court for access to that information. Currently, some probation departments are automatically providing juvenile information directly to federal immigration officials without obtaining authorization from the juvenile court. Unauthorized access to juvenile information can be used to initiate deportation proceedings against a minor and negatively affect the child's ability to successfully fight a deportation proceeding. Lack of clarity in current state law undermines the protection of immigrant children and their confidentiality rights. Here to speak in support of the bill is Angie Young with the Immigrant Legal Resource Center.
Thank you. My organization has been tracking this issue since 2008, has been speaking to the federal government about it, and been doing training and outreach to law enforcement across the state. And our confidentiality laws for juveniles have long been in place. Most states have these kinds of laws to protect minors, to support the rehabilitative purpose of the juvenile court, and ensure minors' successful transition into adulthood. And unfortunately, what we've seen is that despite laws that say here in California that information and files should not be shared to those working outside of the system without going through a court process, they have been automatically shared. And this has led to violations across the state. In particular, here in the county of Sacramento, we saw just in the last year and a half a young girl who was a sex trafficking victim reported, a factually innocent child reported, a child who was legally here in the United States, not even subject to federal immigration laws and deportation reported in violation of these confidentiality laws and process. This bill will clarify that it is unlawful for local and state entities to share this information with federal officials unless they obtain consent from the juvenile court. And it will provide the minor, the parents, and the attorney an opportunity to contest if this is contrary to the child's needs and best interests. And so this bill will really ensure that all children in the state of California's rights are protected regardless of immigration status.
Thank you. Witnesses in support of the bill.
Dennis Garcia on behalf of Communities United for Restorative Youth Justice in support.
Zachary Alsey on behalf of California Attorneys for Criminal Justice in support.
Jesse Stout, Legal Services for Prisoners with Children, in support of this excellent bill.
Dina De Silva with the California Immigrant Policy Center in support.
Janice Stillman with Legal Services for Prisoners with support.
Others in support? Speakers in opposition to the bill? Are there any speakers in opposition to the bill? Seeing and hearing none, are there questions or comments from members of the committee? Or is there a motion on the bill?
I vote no.
The bill has been moved. I don't see any questions or comments. Sounds like a good bill. Would you like to close?
I respectfully ask for an aye vote.
Please read the roll.
Hancock.
Aye.
Hancock, aye. Anderson.
No.
Anderson, no. Glazer.
Aye.
Glazer, aye. Leno.
Aye.
Leno, aye. Lou. Lou, aye. Monning. Stone.
The bill has enough votes. We'll hold the roll open for the absent members.
Thank you, Senators.
Assemblyman Stone. AB 666.
This is Arthur.
Yeah.
Thank you, Madam Chair. Senators, AB 666 clarifies amendments of amends Section 786 of the Welfare and Institution Code, which was added last year in a great bill by Senator Leno. And Senate Bill 1038 from last year provides the automatic sealing of records. So the automatic sealing is already provided in the law. That is today's law. What this bill does is it cleans up the process around how those records get sealed and how courts and others actually administer them. It addresses some of the issues that have been raised since then. So it requires Judicial Council to adopt rules and forms to assure consistent and standardized implementation of the sealing law that was established by Senate Bill 1038. It provides better guidance to courts in determining what constitutes satisfactory completion of probation or supervision, which is a requirement of auto sealing, because not only do the records get sealed upon satisfactory completion, but the underlying offense is deemed not to have happened for that youth. This includes arrest and probation records in the sealing requirement, and it states that an unfulfilled order, condition, or restitution, or a fine that can be converted to a civil judgment shall not delay the sealing of the record. This is a cleanup bill to the current law that protects juveniles and allows them to be able to move on with their lives after a mistake that they had made, get employment, get benefits, move on into go to school, the things that we want them to do to be able to continue and be productive members of our society. I have some witnesses in support, and I respectfully request your aye votes.
Thank you very much. David Steinhardt, Director of the Commonweal Juvenile Justice Program and a sponsor of the bill. We worked very closely with Senator Leno last year in the bill that set this policy and procedure for the auto sealing of qualified juveniles and qualified juvenile records. And I think the author, Mr. Stone, has described the sort of cleanup provisions of the bill. The bill, in addition, does extend the protection beyond the court file to arrest and probation records as well. This aligns the 786 and SB 1038 with the other sealing statute, the petition process, which also provides for the sealing of records from the start of the process to the finish. Basically, sealing the court file alone is not enough and does not adequately provide the protection that minors are promised when they perform all of their probation conditions and are promised the benefits of a sealed record. So the bill does that as well. If there's any bone of contention in the air on this bill, it has to do with post-sealing access. And some of the opposition maintains that the records, once sealed, should be unsealed for a variety of purposes. The sealing law we've had for 50 years in California provides no such open door to go back into unsealed records. Yet AB 666 and Senator Leno's bill did provide very limited access for prosecution and probation to go back and look at the record for very limited purposes. We would just caution that unsealing a record and opening it again needs to be done on a very limited and narrow basis. The offense is supposed to be deemed not to have occurred upon sealing. That's what we promised the minor. The minor has earned that right to sealing, and we don't want to provide second-class sealing that can later blow up in the young person's face. So in closing, our primary goal is to ensure the successful recovery and reintegration of these young people into jobs and colleges and other positive life options. We've seen case after case of young people who are losing their jobs or can't get into the military because they are haunted by a record that has not been sealed. And so AB 666 on the implementation side will make that happen. Thank you.
Thank you.
Madam Chairman, Senators, my name is Arthur Bowie. I'm a supervising assistant public defender from the Sacramento County Public Defender's Office. We're also in support of the bill and join in on the comments of Mr. Steinhardt. I'm here specifically to address some of the concerns of those that are in opposition, such as the Sacramento County District Attorney's Office and the sheriff's groups. Some of the concerns that they raised regarding being able to look at information from previous offenses or previous files involving mental health and other types of information that may be useful going forward, they can get that type of information without having to go into previous files that have already been sealed. Most children that come in contact with the juvenile justice system don't come back. Just recently, the OJJDP put out a report on juvenile delinquency, and it was noted that over 80% of children that come in contact with the juvenile justice system just never come back. So there's really no need to go back and look at anything or have the potential to look at anything that impacts those children going forward. The information that the district attorneys are concerned about, specifically here in Sacramento County, which is probably true throughout the state, can be got through the probation department, can be got through CPS services, can be had through other means other than having to go back and open up a previous file. And in a lot of cases, depending on when those cases come back, that information could be stale, old, and really not that useful to begin with. With respect to some of the concerns from the California State Sheriff's Association, we just heard a member testify just a second ago about the use of arrest records or information about children that have been given over to immigration officials. We experienced that here in Sacramento County, as you heard Ms. Young testify to. This information is being shared by law enforcement officers, and had these records been sealed under 781, they would not have been able to do that. 786 is designed, or should be designed, to protect children that are short-term in the system, that have actually successfully completed very minor offenses in most of these cases, and that information should not be shared because it has a long-term impact on their ability to get jobs, get in school, and as Mrs. Steinhardt specifically noted, to even serve their country. So we ask that you pass this bill, and thank you for your time.